My name is Silke El-Rifai. I'm the General Counsel of Gnosis. It's a bit loud, right? One sec. And we've put together a really nice panel of legal experts and non-legal experts on DAOs. And we're going to talk about the elephant in the room, basically, legal and DAOs, and are legally compliant DAOs, are they more hype or are they substance? I'm going to briefly introduce our panel. I'm starting with Iris Wussmann. She's a professor at Leiden University for company law. She researches the impact of blockchain technology on corporate structures and company law. She's also an expert on robo-directors and artificial intelligence in the boardroom and how these new technologies actually affect corporate structures. Then we have Beth McCarthy. Beth is a legal mechanism designer and also an behavioral analyst. She is the co-founder of the DAO Incubator. The DAO Incubator is a collective incubating DAOs. And she's also the co-founder of the Starfish Network in San Francisco, a co-working space for blockchain. We're also joined by Aaron Wright. Aaron is the CEO of Open Law. He co-authored one of the most authoritative and earliest books on law and blockchain, Blockchain and the Law, The Rule of Code. And he is also going to speak a little bit more about the open law framework. He is a professor at Cardozo Law School. We have also Constance on the other side of the panel. Constance is the principal of 7 Advisories. She's also, as you might know, the co-founder of Koala. And in that role, she has spearheaded this field law for the last 4 or 5 years, actually. Last but not least, I'll introduce the person who has not been damaged by legal education yet. It's Amin Soleimani from Moloch DAO. He's also the CEO of an entertainment platform on Ethereum. And he's going to help us steer. If this debate becomes a little bit too detached, he's going to steer us more into the technical direction. Yes. So there is a Slido, so if you actually have questions which you'd like to ask, you can either shout them here or you can use Slido. And it is code number, let me find this, sorry. 6737, so 6737 if you have questions. Amin, I wanted to start with you. What is the legal framework of the Moloch DAO?
Hello, testing. It has a very sophisticated legal framework. Nobody has signed any paperwork. There is no legal standing. Minority protections are built into the contract, and the only legal advice we've gotten to date is that we're better off without a legal structure.
Wonderful. So so actually, you know, the issue in the frame, the issue we face with the DAOs is that they are kind of illegal. There are so many DAOs. This year actually has been the year of DAO creation. There's been a Moloch DAO, there's been a DX DAO, there is now a Young DAO, there are DAO platforms. So a lot of them, or the majority of them, do not have a legal framework. So I would like to also ask Beth, I want to ask Iris about this first. I want to ask Iris, do you think the Moloch DAO is a general partnership?
Well, maybe, just to make sure that you don't have to sign anything actually to have a legal framework applying to you. If we just decide, all of us, to work together and to generate some economic benefits, probably actually would qualify as a general partnerships, and then a variety of rules, a set of rules will actually apply to our collaboration. So it really depends on what we're actually trying to do. So if there is an agreement, whether that's written or whether that's an oral agreement, doesn't really matter. And we are all contributing to it, whether that will be labor or whether that will be capital or perhaps the use of goods. Those can all be qualified as contributions. Then we probably would qualify as a general partnership. The question is under which jurisdiction. That's a bit of a technical story which I won't go into today.
I mean, where is the Moloch DAO located?
Ethereum.
So it's the Ethereum jurisdiction. Judith, what do you think about that? I mean, does it depend on the members themselves? Or maybe Aaron wants to say something about that?
Yeah, I mean, the jurisdictional questions are interesting. I mean, it could also reside in multiple jurisdictions, right? So multiple jurisdictions laws could apply depending on the issue or whatever dispute may emerge. But I think, unfortunately, to the previous point, there is a legal framework. You can't avoid it. And that's why this is an interesting question. We have this opportunity to really build really interesting new structures, experiment with new forms of governance, all incredibly exciting, lots of progress that's being made. But there are benefits to kind of wrapping this all in a legal entity of some form. I think some jurisdictions are pretty well equipped for that already. Other jurisdictions may adopt, and there's going to be pushing on what these legal structures look like, what the boundaries are, which probably will lead to some changes in the law. But that's a good thing, and that means that we've got safe spaces where we can begin to play around with this incredible technology.
So, please, Ruben.
Yeah, something I wanted to add is just in terms of Moloch specifically, because it's a grants-making organization, everybody who has joined has come in with the expectation that they will overwhelmingly likely lose money. You will come out with less Ether than you started with. And Ether, in not being a security, means that the DAO itself is not a security, and that's part of why it's not to try and generate economic benefit for the members themselves, but for the community at large.
So, please.
Yeah, maybe it's you too. So some of the jurisdictions use profit as the thing that they're aiming for, but economic benefit can be positive, can be negative. So if you work together to, for instance, save costs, you could actually qualify as a partnership, although maybe you're actually not saving costs in the end. So it's a bit broader than just trying to make a profit out of it.
We close the loopholes.
So Iris, do you still think that the Moloch DAO is a general partnership even when it's not making any profit?
Well, I haven't specifically looked into your governance system and what you're doing. I only know that the key thing is that you invest whatever you can invest. It's probably open, but a contribution is also very broad. So whatever that may be, it could qualify as a contribution. And they're working together, and they're trying to do something which probably either generates something which is negative or positive. But I'm not sure. I should have a second look at that.
I mean, most of you probably ask yourselves, you may be creating your own DAO, and you want to know what should we actually take, how are we going to do this legally? How are we going to structure it? Do we need a framework, or are we going to do it like, Beth, do you have any advice on how to do this? So from a legal mechanism design point to approach this question?
So I think the thing that's really useful about using these concepts of legal design, and by legal design I mean thinking of the law as not only being these certain legacy systems that apply rules and punishments and like create a regulatory structure based on jurisdiction, but also abstracting away from that a little bit to think of it as being, just a formal system of logic that includes incentive structures, that provides functional roles, provides, a grammar and ontological framework for existing in, collaboration and working together. And so from that perspective, I think that, the question of, is it a partnership, is it, an LLC, is able to be approached in a way where those are also kind of design constraints for saying, what are you hoping to get out of an organizational structure that would be classified as an LLC, and, how can those characteristics be applied across jurisdictions, and, what parts of that don't work, and, by kind of asking these questions from a design perspective, then you're able to say, the certain flow of incentives, the certain flow of power, this assignation of functional roles makes sense for our organization, and then these other questions of legal personality and jurisdiction can flow from there. So, yeah.
So, obviously it would make sense to join the DAO incubator and get Beth's advice on that. But there has been a lot of discussions recently on having limited liability DAOs incorporated in the United States. There have been quite some academic thinkers actually that spoke about having 0-member LLCs and basically have an operating agreement. Aaron, you've been working and experimenting with this at Open Law. Could you maybe tell us a little more about how this works, or how this is actually an option to structure the DAO legally?
Yeah, sure. The big question and the big problem here is if you don't form a legal entity, then you as a member are potentially putting your other assets at risk to creditors of that entity. And so that's why in the US and in most jurisdictions around the globe, we give folks the freedom to experiment through legal entities. They have a limited liability. That means if you're participating in some sort of activity, something goes wrong, the assets of that entity are really the only thing that a creditor can try to recover, not your personal assets. And it gives people a tremendous amount of freedom. It's kind of one of these bedrocks of capitalism and other forms of systems. So people can experiment, so people can engage in fruitful social or economic conduct. In the US, there's a very, very flexible entities, mostly limited liability entities that give folks that security that they're not going to necessarily put their assets at stake, but at the same time they can order their affairs. So there's a broad concept of just private ordering, which is using contracts. So me and you agree that this is how we want to govern our relationship, or a group of people can agree together that this is how they want to govern their relationship. Fortunately, in the US, it's pretty much like a blank slate. So think of it, if you're like a programmer, you pretty much have as much flexibility to engineer anything you want legally with certain constraints. But that means that you can pretty much absolve away certain legal requirements. So if you want to say, I'm not going to be a fiduciary, I'm not going to have extra requirements in order to operate this organization, you can put that in a contract, and that's basically how it's going to be enforced. Or this is how we want this organization to be governed, we can articulate that in a contract in some sort of way so that you can have things like delegated voting or more interesting voting schemes or decision-making processes. And that can all be kind of hard-coded into a paper legal document and can be mirrored in smart contract-related functionality as well. So I do think in the US and probably in other jurisdictions, my expertise is more in US law, we do have kind of the bare bones to begin to experiment with DAO and DAO-like structures, some of the really exciting incentive and voting mechanisms with certain constraints, mostly around the size of them. So that's the one thing. But that means that you can actually have for-profit DAOs. It's completely feasible that you can set these up. So building on the great experiments that we saw in the past with the DAO, I think you're going to see over the next year new structures that try to mimic that activity, are for-profit, are not necessarily just charity or gift-based, that actually enable a lot of ecosystem development in this space.
So on the European level, I'm not entirely sure, is this also possible? Can we do this like LLCs that house a DAO through an operating agreement? And Iris could maybe speak a bit on this.
Yeah, obviously in the US you have many states with their own jurisdictions. In Europe we also have a lot of jurisdiction with their own entity forms. In Europe we do have corporate law on the European level, but a lot of that is directives which need to be implemented in the different jurisdictions. But if you look at corporate law, the states, the member states have their own how can I say this, the right to have their own entities. So it depends which jurisdiction you look at. For instance, if you look at the Netherlands, we don't have such a thing as an LLC, or we don't have partnerships with legal personality, but we do have corporations that are very flexible, mostly more flexible than the corporations which are created in the US. But we have limited liability partnerships, which is an entity form, a legal entity form, which gives you a lot of freedom, the freedom that you also have with LLCs, to organize who is actually the one who decides the rules, who is the one that can amend the rules, and who are the ones that are actually receiving financial rights. Giving you also legal personality, which means that there is an asset partitioning aspect to it, which means that the legal person itself has its own assets, which are separated from the assets of the members. So that's quite similar to LLCs. The only thing is that you will still be liable for your own acts. So the benefit of LLP, so limited liability partnerships, is that you won't be liable as a member for the acts of your fellow members, but you will still be liable for the acts that you have performed yourself, whether that will be under contract or under tort law.
So if we want, I mean, you know, most people that working on the DAO, I mean, what we really want, or that's maybe I speaking for myself, is I want the code to get the legal personality. So that the code is the DAO, and I mean, in the legal world, the DAO is a non-person unless it is in one of these, somehow has a legal wrapper, or it's housed in an LLC or maybe another Dutch entity with a similar framework. But what, I mean, when for example, we were working as a Gnosis, we're working on a DX DAO, we're looking at how we could actually have a legal framework and limit the liability without going to the US and being close to the SEC or different regulators. How can we actually do that and have the personality attached to the DAO? I mean, Constance has been working on with koalas, hoping to change the law. I mean, how can we do this? Is this just me dreaming about like having the smart contract being the legal person to adapt, or can we?
Well, unfortunately, it takes time. It takes time, and it's a gray area of law. So a lot of things need to be replumbed, figured out. I think that a couple of things, it's been a really interesting conversation, and I would say that one thing I would caution is seeing this as kind of a binary outcome between let's instantiate our DAOs in some legal form, option A, and then option B, let's stay in this illegal space where our jurisdiction is that of the blockchain. So I don't think these are the two only outcomes, and I don't think it's going to be likely that these are the only outcomes. There needs to be, one thing that we've been working on in Koala, actually, with the input of a lot of you guys and various experts, is figuring out, okay, what regulations are we talking about here when we're talking about various corporate forms or organizational entities, regulations around liabilities, around decision making. What are the current rules, which are across jurisdictions very similar? What are the mechanisms that are used to enforce the rules? Why do we have these rules? What are we trying to achieve with these rules? And then what are the technological equivalents that we can achieve in the blockchain space? And is there a new framework that we can create that provides a spectrum of options, so that if you want to afford yourself of the kind of legal personhood and right of contract and limited liability of a particular legal entity, perhaps you do need to adhere to XYZ rules. You know, if you want to maybe only partially have this kind of legal liability, maybe you only want a legal avatar to reach out into the world, you know, for to hire people or to enter into contracts, but you want to operate your DAO, you know, in the virtual space. Maybe there's a in between. Maybe there's a spectrum of certain technological guarantees that you can meet, while meeting certain other more traditional legacy forms of legal requirements. So, you know, unfortunately, this takes a lot of translation and time, because the law, on one hand, presupposed a particular kind of architecture and infrastructure, and the entire architecture of the laws are posited around this kind of structure. In the illegal space, in the DAO space, obviously, you know, we're talking about very different stakeholders. So even translating what you know, what a last known person might be for a DAO, you know, with all of the various contributors and actors, it's an open question. It's a difficult one for regulators. So that's going to take time. But I would say the other thing that I think is very hopeful for the space is that there's a lot of angst and focus on the exogenous rules. So what are the rules that the outside world is going to impose upon us right now? And that's you know, as I just discussed, you know, a very slow-moving, expertise-laden process, which involves a lot of translation between different domains. On the other hand,
the regulators.
And regulators and various jurisdictions and incumbents and all sorts of different political dynamics as well. On the other hand, we also have the opportunity here, because this is such an open space, because, you know, regulations and, you know, how the internet space is going to be governed, how data is going to be governed, is now being seen as such an open question. There's an opportunity for us to create endogenous rules. So what can we, and I think Mulak DAO is a really wonderful example of that, of how can we, in our illegal space, create rules that allow us to achieve the same kinds of goals that regulators would want us to see. So how are we managing minority rights? How are we managing custody of funds? How are we maintaining safety and soundness while retaining this permissionless aspect? How can we slice and dice this as a community? Can we, and because we're creating an ecosystem and it's not just one person, how can we come together to do this?
I, for one, hope your dreams come true, and that the law recognizes DAOs as legal individuals, because then it would recognize Mulak as a legal individual, and that would be really cool.
I mean, in the US, your dream is already a reality. I mean, you can have an LLC structure, which is a legal identified entity, no members, no management, and the software is just placed in it. So it would have the limited liability baked in it. If you want governance on top of that, that's where it becomes a trickier question. I mean, an open source license, even of it, sorry, didn't mean to cut you off. An open source license in and of itself is an easy way to get limited liability for software for many different activities. I think the headline, though, and one thing that folks in this space haven't recognized in a lot of these challenges, is just the power of contract law. Contract law is incredibly powerful. Particularly in the US, your ability to order your affairs with other folks is, if it's documented in a contract, it provides a tremendous amount of freedom and flexibility, as long as the activity, for the most part, is not criminal. And that's exciting when you think about all the potential use cases, particularly the socially minded ones.
But yeah, I mean, but Aaron, you know, there's a lot of research going into this, whether it's actually really possible to do this under US law. So they started to say in 2015, there's this wonderful scholar called Sean Byrne. He started to come up with this idea that you can have this like memberless LLC, where in the end you get rid of the members and you have just this code sitting there and an operating agreement that kind of has the people work for that code. But there's also been a lot of discussions on this that is actually not what the regulator envisaged. So that they actually the regulator doesn't really want to have these memberless LLCs. There's this in New York statute, there's this 90-day rule, and somehow there have been arguments that you can get around that. But in the end, I mean, if this ended up in front of court, I mean, it's likely that the regulator says, well, that's not what we intended. That is not, I mean, for me, this is not a long-term solution as to getting a legal framework for the DAO. I mean, we did a contractual one. So when Gnosis initialized the DX DAO, it has a contractual framework only. So we opted for.
The answer is, I think it would be fine. The power of private ordering, in particular in certain U.S. jurisdictions, it trumps a lot of things. It's just one of these baseline precepts that undergirds the entire American legal system. That if two parties, and if they're competent, agree to something, it's going to be maintained. So for example, with an LLC, you can basically waive all your responsibilities. You can say, I have no fiduciary obligations over this. Now there's a question as to whether or not why you'd want to do that, but in certain instances that's proven useful. Those are enforced. Those have gone through the courts for 30 years, and they're enforced. So if parties want to agree to certain activity, it's going to be hard for a judge to say, okay, you can't do that. That's just not how the US system works. We allow people to engage in commercial activity.
There's some disagreement in the panel here.
Well, I'm not sure. I'm not a U.S. lawyer, so maybe that's good to say. But I think Sean Byron sort of based his idea on this algorithm agreement equivalence principle, which means that he says if you have an LLC which can be memberless, and I agree that it's possible to have an memberless LLC, the question is for how long, because probably there will be a dissolution at one point. But then the legal person needs to be represented, because the legal person itself, the LLC, it's a fiction. It's not something which is tangible. So normally what we have, if you have a legal person, which is a corporate or an LLC, you have people that are actually representatives. So they can represent this legal entity so that there can be legal acts with legal effects. And this principle of Sean Byron is based on the fact that he says that a computer code can be representing the LLC to have legal effect. And I doubt whether that's actually true. And he gives 3 arguments for this to work. He says, well, classical contract law is on the decline. And he says there just needs to be one jurisdiction in which the court upholds this principle. And then he says, well, common law has yielded to commercial pressures. But those are all arguments based on uncertainty. So it doesn't actually say that this is valid legally. It just says we're going to try this, and then, if litigation starts, we just see what the court will do. It doesn't mean that it's actually...
Yeah, but these are the same arguments around open source licenses. But to Constance's point, if you experiment, you're adding value into the ecosystem, these types of questions just get, although gray, there's always gray in the law. You're going to talk to a lawyer, they're going to say it depends over and over and over again. But usually, particularly I would say from a US perspective, pragmatism wins. So if there's some value, if there's a need for this, for folks to deploy code, know that they're not going to be liable for it, and it can coordinate activity, that activity is socially or economically beneficial, I would be shocked if the US or a US court doesn't say that that's okay. Now that may be different in other jurisdictions, but from a US perspective, that's just how it works. In general, and I think that pragmatism, when it came to internet policy, has tended to win. I think even though, despite the bumps, with blockchain-related policy, we're going to see the same endpoints of pragmatism.
I totally agree that, experiments are good, and I think we need to innovate, but there's a difference between something which is certain and which is uncertain. So to say that this is something which is really there and can be used is one, but whether it upholds in court is 2. So if you choose to do this, which I think it's a good thing to do, so I agree with that, there's still quite some uncertainty whether it's actually going to be upheld. Yeah.
And we're still talking here, though, about global organizations and DAOs that need to have more freedom than recognition just by one jurisdiction, and also, I would just in our mapping exercise, we're running into some serious issues around principal-agent problems and using algorithmic governance to deal with corporate governance and how to get to this last natural person. I would say the other side of this of contract law, which there is, at least in the United States, great power to deal with lots of things in this private law sphere, which we can mechanize and automate very efficiently on the blockchain. There's the public law sphere that we haven't gotten into, which I think is also equally important. So these are the kinds of rules that we as individuals in this ecosystem cannot contract away. So, what happens if there is an assassination contract, launched on mainnet? Who is responsible?
The developers?
Exactly, the members. If we are not in a limited liability context, it could be potentially everybody who participated in the project. So these things highlight the need for us to deal as a community and as an ecosystem with the public law aspects. And so I would say that we really need a legal commons. So we need to experiment more with these kinds, with Blue Lock DAO, with other kinds of mutualized cost sharing, insurance, other vehicles that we can, pool together in order for us to have these common defense when things are, attacking the ecosystem or things cannot be contracted away. And so I think that the more kind of steps that we can take proactively as a community to deal with both the legal compliance on the public law aspect as well, and show more steps in that direction, I think that the better off the development of these legal frameworks will be.
Yeah, the assassination DAO. Don't start that.
Oh, come on, but let's not talk about assassination. What about fiduciary duties? I mean, so for example, with Moloch DAO, are the members, or like the persons or the summoner, are they fiduciaries?
So, I mean, if it's a partnership, then there may be
But we don't know yet.
So
we haven't yet decided whether they are
it's all branch logic, right? So one assumption, it may not be a partnership under U.S. law, particularly because it doesn't generate a profit. That's a tricky question, period. So that answer is going to be, sadly, it depends. Let's assume that it is, though. Just for purposes of argument's sake, in that instance, there would be fiduciary obligations. Unless there's a contract, right, that waives those, and it's housed in some sort of limited, like an LLC of some sort. If it was housed in an LLC, you could waive all those fiduciary obligations. You wouldn't have these questions about potential liability for a partnership, and you can kind of move forward with that.
Fiduciary in the context of like try to make everybody's money worth more, or like keep
fiduciary,
it safe?
like you have extra responsibilities as to your partners and to other folks that are participating in the organization.
Yeah, I mean, the reality is like I would feel personally responsible if the contract was to explode and all the money was to be lost. I would have absolutely no way of covering for it. There's $1.3 million in the contract at this point, and I wrote the code, the last final to launch. I wrote all the tests. I reviewed the audits, so I did everything I could, and like. There was several $100,000 in the contract for several months before it received more money from EF and Consensus and Joe and Vitalik and crossed the $1 million mark. I wouldn't really know how to deal with that kind of liability, but I would hope that they wouldn't like press charges,
Could hire Aaron as your lawyer. So I have a further question to you is, how are you going to deal with pseudo-anonymity? So some areas or like parts of the community would very much like to see that. And there are also some other structures. So you have, you can also have, for example, a mutual, you can use a mutual or, in the UK or a cooperative. There are other structures, but they are, in my opinion or my knowledge, they fall down on like allowing members to not be anons in that space. Does anyone have a comment to that? How about it?
I can take that. So I think a lot of this is what is the purpose of the DAO. So really, if you're trying to create something that is going to generate a profit in some capacity, you're running into just a question around securities law. So there's an argument, at least in the US, if you've got an organization and all the members are participating equally, then the partnership interest or LLC interest or LP interest, if it's organized in such a manner, will not be considered a security. If not, then you run into the same questions we dealt with the ICO market, et cetera. And if you want to do this above board, and if you want to have participants that have complied with securities laws, there's ways to do that, but it requires actually identifying who the person is, at least to one party, right? So there needs to be some sort of accreditation check. There may need to be some other compliance checks, and that creates an issue. It's a trade-off.
So I don't have this, like centralized entity that does my KYC, no?
So that's the question. So, really, for purposes of securities law, the entity itself needs to do the verification. It doesn't necessarily need to signal that to all the other members. So there's a conceptual idea that you could have basically an administer, make sure that these requirements are taken care of without disclosing the identity to third parties. Obviously, as some of these more decentralized ID systems come out, some of those requirements could actually be stored in those types of systems. So like, some future MetaMask 3-box related system.
Identity,
Yeah, I think pseudonymity is important for permissionless innovation. But I do think that there needs to be kind of a corresponding governance function as pseudonymity it becomes more prevalent, because you get issues around when participants are pseudonymous, then you can get into issues of kind of undue influence. You have whales, you have hidden actors and whatnot. So having a really good governance layer on top of pseudonymity, I think, is going to be very important.
I mean, and also just taking into account the reality of how, DAOs operate, where there's, discussions in forums, there's a lot of, off-chain relationships that are built, at this conference, like, the need to be able to be accurately reflected and accounted for, I think. Like, I think it's a fallacy to assume that people can operate completely anonymously because, you're talking about a system literally based on reputation, based on decision-making, like people make those choices, based on the other people involved and, like the choices that they all make and the risks that they take together over time. So I think that if there's a need to separate anonymity from, the securities view of anonymity, and also one that, from in the day-to-day life of this DAO, especially as it's used for more of a, governance mechanism among people, then, how do we account for both and have language that addresses both?
So in my mind, the math anybody who is doing when they're thinking about launching a, for example, for-profit DAO is, what's the cost to the DAO of complying with regulations versus what's the cost of doing this completely anonymously and dark? And the dark way of doing it is like everybody gets burner phones. We have secret Telegram groups. There's no in-person meetings. Like you always have to use a VPN. Nobody really knows each other. But that seems like a large amount of effort just to buy things and generate profit. It's like you're not trying to kill anyone. This isn't like a terrorist cell or something. It's just like a bunch of well-meaning people trying to generate a profit, but might not be accredited. They might not have enough money to be able to do that. And then instead, the alternative is you have to KYC everybody and make sure everybody's an accredited investor, and that's really lame, but probably the pragmatic approach given where we're at today.
So are you suggesting that, anyone who wants to be an anon, that must mean there is some nefarious activity involved?
No, what I mean is that that's an extreme length to go to for non-nefarious activities.
Yeah, I think one way that this entire ecosystem could develop, you start with, known DAOs where the entities or parties are known. And then you work kind of backwards from that. Or you have kind of an intermediary that kind of provides that shield of anonymity. Now you'd have to trust that intermediary to do the checks, and that party would not disclose that to other members. So that may be a compromise, but there's a trade-off here. And if you do want to do it with burner phones and all anonymous, that's great, but you're probably not going to have the reach to fulfill whatever mission or either economic or social purpose that this entity or organization is trying to fulfill.
Yeah, just to ground this in practicality, in Moloch DAO today, in the grants-making organization, we also have accepted a few anonymous members. So some of them are anonymous to the rest of the DAO, and maybe 1 or 2 members have vouched for them. There's some I've vouched for. They identify themselves to me, and then I vouch for them. And then one of them, actually, I have no idea who they are, but I was like, give me a reason to let you in, and they just sent a transaction from a key that had received Ether in the Genesis block. And I was like, all right, fine, that's good enough, you know, you're in. And then we also have now launched the Moloch Pool, which is a separate smart contract that allows anybody anonymously to donate to the pool, and the pool will automatically do follow-ons. And like, that's a sort of other question where like you could have the DAO be identifiable, you know, have identified members, but then like a separate contract just springs up with no coordination with the DAO members that just also gives money to the things the DAO gives. What's the DAO supposed to do about it? Fun questions.
Very nice. We have probably another 10 minutes to go. We had the Slido desk, but I wanted to open up the questions to the panel. I'll just ask you guys here, we're not that many, so how about we just need a microphone probably to if you have a question, just stand up and come up here, then you know you can ask a question. Oh.
Yeah. Do you want to give it to me?
Wherever.
Hi, my name is Kislinski Vladimir. I represent here the Swiss startup from Zug, the name Curio, and I'm super excited about the topic, the competent of DAO. And 1 year ago, I already deployed in the Ethereum network the DAO. I have 0 volume, and right now I'm preparing the DAO for our Swiss project. And when we become, you're speaking a lot about the legal. I can say the DAICO, the IC OVO. Do you know this?
So,
IC OVO. This DAICO already working with the legal inside the Swiss. And you many times speaking about this.
sorry,
We're getting
It's
away.
really
it's
hard
very
to...
hard for us
Yeah,
to understand. What's
just the question is, you are from Consensus, you are from Gnosis, you are the super big, and the problem of the DAO, on my idea right now, it's not enough volume, not enough customers. It's not about the legal, actually. It's about the customers not believe, and customers don't see the support from the big industry of the DAO. You say every time about Moloch DAO, it's just 1%, but we have the Maker DAO, we have the DGX DAO, we have the Abyss, we have another one DAO.
Yeah.
And the question is, how can you, like a big guys, big crypto, support 1,000 DAO projects where 100 just projects good and 900 die, but can you support many startups? Not 30K, because I have the Moloch DAO, I know 30,000, or another one 30K. Yeah, thank you.
Oh. So is your question, just let me try.
My question, can you please, like a biggest,
Sorry, I understand. So
like super big companies support the DAO, not just Moloch DAO? Can we do 100 Moloch DAO?
sorry about that.
Oh, yeah,
but
so
the thing is, we're not just talking about Moloch DAO. It's just a
It's just an
more general
example.
discussion. It's just one of the examples that doesn't. So the Moloch DAO doesn't have a legal framework. So we're speaking about that because a lot of the DAOs don't have a legal framework right now.
Well, let me.
So
So let me. I would say the tooling, in order to create DAOs, it's just the cost and expense is going down. It's a lot like what we saw with the token standards, et cetera. Some of the great work that Amin's done with Moloch and other projects, we're starting to see some mechanisms in just the smart contract design piece that we can begin to use and experiment with. Some of the tools that we've developed on the open law side can open up potentially these legal wrappers so that they're available for other folks. And the great work that other people are doing is trying to really understand what the model should be, right? Like, what is the right way to structure this off the bat? But if you have tools that open that up so that anybody can generate, let's assume that there may be some legal documents that are going to be necessary in some format. Those could be automatically generated with some of the incredible smart contract work that Amin and other DAO projects are there. We can start building DAO factories, right? We can actually start imprinting them, and we can not just have it for large projects, but also for small projects. And that's the vision I think lots of folks are working towards.
And Consensus and Gnosis and people only support Moloch because Moloch is useful to them. Right? It does something that they want in a way that they otherwise wouldn't be able to do themselves. So like something like Metacartel, totally separate than Moloch, awesome application level experimentation. You might, like Gnosis has just recently submitted 100 Ether to that to join as a member. Like you could see that playing itself over and becoming a template for future DAOs who decide to take on some area of ecosystem development and then show progress and then receive support from EF Consensus, well-meaning Ethereum community members and in other communities as well. But it starts with one. You don't get to 1,000 without starting with one and then the next 3 and then the next 10 and so forth. Okay. I hope that answered your question.
Hello, my name is Denison Bertram. This question is kind of directed, I guess, at Aaron as also Amin. In terms of like the legal risks of something like Moloch DAO, for example, being not incorporated, because at the moment, there's the idea that ETH is not a security, so that sort of protects the members of Moloch DAO from securities law, but then sort of puts Ethereum more into the realm of a currency. And one of the projects you had spoken about funding online is something like an Ethereum mixer to add to anonymity on the Ethereum blockchain. But that, at least to me, starts to sound something that falls under RICO laws, because now you have a group of organizations which are pooling their funds and they're supporting a tool which allows for money laundering, which is specifically listed as something covered by RICO laws in the United States. So I'm kind of wondering, like, where do we fall in terms of like the gray area of like not having legal protection? Because at the moment, if, for example, one of these mixers was labeled as an organization that you were funding, it sounds like everyone who's contributed to Moloch DAO would actually be pooled together in that.
Yeah.
I'm going to ask my lawyer for help here.
Yeah, I would. That's a great question. I think the answer is there's lots of gray areas, right? When you pool together funds and you allocate it out, either for profit or for a loss, it's going to create questions of corporate law. It's going to create other questions, which could implicate other laws potentially. And that's why we have legal entities, right? They're not awful, they're not evil, they're just trying to limit the liability of members so that they can engage in activity. And if something awful happens, then you can handle it on kind of a case-by-case basis. So, from taking a step up, I think the idea and something that would be great as an ecosystem to push for is just creating safe spaces so people can experiment with this. They can experiment with these new structures, they can experiment with new forms of governance, they can experiment with some of these incredible voting schemes, and they can try to make the world a little bit better. I mean, that's what I think everybody, for the most part, is in here. Some people obviously want to make a little bit of a profit, nothing wrong with that too, and we need to just kind of sort that out. But there are risks, right? There's going to be risks in the US, there's going to be risks in Europe, so we need to start thinking about it and coming up with holistic solutions that can be replicated so that we can begin to see this ecosystem flourish.
I wish mixers specifically, like we branded them as like secret Santa machines, it's just like, send money to your friend, they won't know who it came from, but that would be really fun. Not like, this is for money laundering, because it's like, more it's for like transactional privacy, and privacy is a fundamental human right, I would think, or I would prefer to live in a world where that was true, and like, everybody tries to bring the money laundering thing into the conversation, but it's like, I just want to be able to get ETH to an address that doesn't have a trail without having to go through an exchange. It's like, I'm not laundering, I pay my taxes, like I'm doing all the stuff. It's like, yeah. No, it's not, unless you are, no, it's just you.
I mean, legally.
And we've been through this rodeo
what you
before, right, with the internet. So, you know, it also allowed all of this activity that hadn't been, allowed before. There's an open question of whether people were being compliant or not. You know, the dark side of the story, of course, is that we saw a re-centralization of the internet because incumbents and default structures came into play, default power dynamics. So it's a good lesson for us as a community trying to get a second bite at the apple to be really thoughtful about how we can be proactive in structuring our relationships, our community, our norms, so that that we can actually create something new instead of replicating the old structure on top of a decentralized architecture.
I mean, one thing you also have to make sure is that when you have an application, there's at least one legal use for it. So if you do actually build something that has only illegal uses, that's going to be a problem. So, I mean, with the mixes, what you still can argue is there are actually privacy concerns, and what just Aaron and Amin just mentioned is there are legal uses for this, which you can still argue. But if you build something that's just illegal, then that's another story. And you can be reliable for that as a developer, if it's just a legal structure.
We can talk after if you want.
Yeah, there's more time. We're overrunning a bit. We're just going to take, it depends on you guys, you want to end it, but I think we should take 1 or 2 questions, so yeah.
Hey, my name is, oh geez, that's loud. Hi, my name is David. I'm really curious to hear your guys' thoughts on conflicts of interest. You know, people that may work for different DAOs in the future, their participation might be a legal issue, their decision-making might be a legal issue, and without having some sort of like check on their identity at some level, just wanted to hear your thoughts. So it's not a specific question, but I'm curious about, yeah, conflict of interest law and how that might apply to DAOs in the future.
So conflicts of interest really get implicated by fiduciary obligations. So if you're a fiduciary, you can't just think in a very simplistic way, you can't just think of your own best interest, you have to think kind of in the interest of the entire group. So you're kind of almost like a parent, or it's kind of a quasi-parental type of relationship. Very simplified, I'm sure people can argue about that, but just to conceptualize it. Yeah, and then that may be one reason why you don't want to have anonymity, right? But I think at a high level, and what Soka was trying to get at, well, maybe we want to experiment with, maybe there is a plateau for anonymous folks to get together, and those conflicts of interest, which we can think about and understand, maybe they're not as profound as we initially thought, or maybe there's other mechanisms that we can use to kind of address them. I think these are questions that the law has dealt with a lot. Not surprisingly, people on boards try to pocket something for themselves, and there's certain rules that are put in place to guard against that. But at the same time, they can be waived, at least in the US, with certain legal entities. So.
Yeah, so if you want to waive your fiduciaries, you should come to Aaron, and he can help you with the open law project.
Cool. Yeah, I'm a big fan of open law, by the way, so awesome.
So,
thanks.
Thank you.
Thank you.
So my question is, now that it becomes easier to join DAOs as well as to start DAOs on different platforms, so now there's really need, like probably in this room, many people want to start DAOs or join DAOs, but and they want to comply and they want to be compliant. They don't want to take risks, but they do want to innovate and to be part of innovations. So what would be the healthy and proactive way forward for them to not avoid interacting with this new technology and these new collaboration networks, but to be able to participate without taking too much of a risk? Is there some paths that you're familiar with right now, or some steps that you recommend that they should take in order to, again, innovate while being compliant?
May I answer part of this? So one thing you could do is definitely incorporate yourself. So people do this, so you could just incorporate yourself and then as a participant in a DAO, and that would give you some protection, because then you still would need to pierce that corporate veil, and that's all possible without you having to form an LLC or make sure that the DAO you want to participate in actually is an LLC or has some legal framework, or you are happy with, so without having to really do too much legal analysis. This would be one way. Of course, it's also expensive and not ideal. I mean, I think in long term we just need to change the laws, and this is going to happen. I mean, we're working on this.
So I think it's laws, but I do think the tools are coming. So really, like I think 2020, not just 2019, but 2020, we're going to continue to see a lot of innovation. The great work in kind of structuring and thinking about how these should be structured, I think we can reduce them down both on the agreement side and also on the smart contract side so that the costs are lower. At least I know from the open law side, we're committed to making this all open source, and our automation tools are going to be all freely available. So hopefully that, if we can get a model that can really lower the cost. So it's as simple as basically, npm install DAO, right? Done.
Right.
Like that's what I think we're all kind of working towards.
We're going to take one more question, and then unfortunately you have to wrap up because we're already over our time slot.
Yes, hello, my name is Leo. Great talk. We started actually experimenting with the DAO concept, so we deployed our DAO on Aragon stack. And the question is, do you think that actually for the DAOs, the legal framework is necessary, meaning that if you use like code as the law narrative, meaning that it's actually the smart contract obligations between participants are more deterministic than conventional law, where there's actually interpretations, different courts which are not agree with each other, and if you were implementing smart contract between those participants, it's actually more deterministic. So in terms of DAO being kind of enforceable or legally compliant, does it mean that there's supposed to be some new way of controlling, some new way like on-chain courts or something like this, like what Claris is doing in terms of that? Thank you.
So I think that's a great question. Also describes why you need contracts. So in contracts, the members of the organization can choose what they want to use to resolve disputes. And in most jurisdictions, if that's a contract that's validly entered into, it will be enforced by the courts. And there's a very narrow window to challenge some of those decisions. So it's conceivable you can kind of build this closed loop system, which is what you're describing, where people say, hey, I want to be governed by these smart contracts. If there's a dispute, I want to go into some sort of decentralized arbitration system. But you need this wrapper around it. If you don't have the wrapper, you don't have the safe space to begin to start doing that. And if there's a problem, then the public sphere or other forms of jurisdiction can start to creep in much more heavy.
And maybe good to add is that if you look at partnership law or LLC law, most of the set of rules is default rules. So if you forget to put something in your contract, then this default rule comes to life and applies to your organization. And that's the beauty, I think, of partnership law and LLC law, is that it's very, very flexible to make your own choices. But if you forget to make a choice, there is a rule applying to you, which...
decides to make some default procedure, it can do it because it doesn't control the smart contract.
But the thing is, the problem is that they will get to you because you live in this physical space. So, I mean, as long as you, there's someone involved in this, I mean, even if the court tries to do something against the smart contract, they will get to you, and you will be, in the end, obliged to conform unless you try to run away. So even if, we build this justice system, I mean, you could just have an on-chain justice system in this Ethereum jurisdiction, but in the end, I mean, if a court wants to go after you, it's just going to go after the developers, it's going to go after whoever they can find. It's like going to be the lowest hanging fruit. So if you're not an anon in your system and something happens, they can get to you, because in this world, it's still the legacy world. It's the law that counts and not what your smart contract says. I think...
Yeah, one thing I'd add is just the risk of giving up sovereignty to it's saying, sorry, time is over, sad. Okay, we'll talk after.
Thank you very much. I mean, the answer to this was really lawyers. It all depends. So, thank you.